Good morning. The Canadian Civil Liberties Association is releasing a major report on the bail system in Canada today. Titled Still Failing, The Deepening Crisis of Bail and Pretrial Detention in Canada, this is a follow-up on our 2014 report on bail, Set Up to Fail, Bail and the Revolving Door of Pretrial Detention. Our 2014 report on bail is regularly cited by the Supreme Court of Canada and courts across the country. This report, like that one, was based on court observations across Canada, interviews with criminal justice system participants, and analysis of extensive data. The findings are dire. The proportion of people being denied bail in Canada is at a record level. The charter right to a timely bail hearing is often violated. Conditions in pretrial detention in our country are dangerous and inhumane, and vulnerable and marginalized groups continue to be unfairly denied bail. The Canadian Civil Liberties Association calls on federal, provincial, and territorial governments and justice system participants to recognize the true crisis of the bail system in Canada and implement the evidence-based recommendations found in our report. The report was authored by Laura Berger, Nicole Myers, and Abby Deschman, and I am pleased now to turn over this portion of the remarks to Professor Nicole Myers, a criminologist at Queen's University and co-author of the report, who will outline its findings and recommendations in further detail.
Thank you. We are facing very serious and long-standing and deeply entrenched issues and problems with Canada's bail system. Despite political rhetoric of leniency, slogans such as jail, not bail, or appointing like-minded judges and justices of the peace, bail is not a question of leniency, it is a constitutional right. The crisis that we are experiencing is an over-reliance on pretrial detention, on supervision, and conditions of release. For example, in 2021-22, 70% of our provincial jail population across the country was in pretrial detention. Here in Ontario, it sits at 78%. The rate with which we use pretrial detention has more than doubled in the last 40 years, and the number of people in pretrial detention has quadrupled in that time. Across Canada, 51% of cases conclude with all charges against the individual being withdrawn. This means they are not found guilty of what they have allegedly done. Now, some key findings from our report indicate that very little has changed since 2014. Over 79 days of bail court observation between June and November of 2022, we observed 1,284 bail appearances and conducted 33 interviews across Yukon, British Columbia, Manitoba, Ontario, and Nova Scotia. We continue to see similar issues we saw in 2014, where cases are not being reached because the court has simply run out of time to hear additional matters, despite accused and their counsel being ready to proceed. Each and every day, most accused are adjourned to another day. What this means is a short-term detention order is imposed as the most routine and common outcome in bail court. Most of those who are adjourned are being adjourned for the purposes of developing a release plan, trying to meet the requirements of the Crown to secure release. While very few people are formally denied bail, lots of people are held in limbo, where they stay in pretrial detention until the resolution of their charges, without a bail decision being made. When folks are released, they're most commonly released with the consent of the Crown, rather than after a contested show cause hearing. But when released, most accused require some form of supervision. This may take the form of a surety, a family or friend member who's going to supervise them in the community, or a bail supervision program. And overall, half of people released are released to some form of supervision. Conditions of release that modify behavior. On average, we are looking at 5.9 different conditions imposed on people, and that this ranges from 1 to a high of 24 separate conditions of release. not a single individual that we observed was released unconditionally. The types of conditions that are most common include weapons prohibitions, not attending at particular addresses, not entering a boundary, and not contacting the victim. Other common conditions include residential requirements, reporting requirements, and curfews. There does appear to be a reduction in the use of abstinence and treatment-based conditions following the Antic and Zora decisions. But what we must be mindful of is each and every condition, once imposed, it is a criminal offense to violate that condition, and that conditions are often criminalizing behavior that is not a criminal offense outside of a court order. We must be mindful of the differential impacts that bail supervision and conditions of release have on different populations. Those who are most marginalized in our communities, those who experience colonialism, racism, poverty, mental health issues, and the criminalization of substance use, experience the most restrictive and onerous aspects of our system. The Supreme Court of Canada's decisions have had a mixed impact on decision-making practices. When we think about ways to go forward, what we need is radical change in our bail court system. We need systematic data collection and study of the bail system so that we can understand changes over time. What is necessary is for us to develop a principled approach with clear objectives and guidelines that are meant to provide structure and guidance to those who are making difficult decisions, but while making sure that we center the fundamental principles and legal rights to bail. We only have so many resources available to us. What we want to do is focus our resources on those that are most serious, those that are most risky. And what this means is that we need to shift our attention away from bringing in more minor matters into the bail court. Case processing issues continue to be a difficulty at all stages of the criminal court process. One of the things that we may want to consider doing is encouraging the courts to remain open until all matters have been heard to full completion in that day, and that disclosure be provided to defense counsel in preparation for bail hearings. We need to recognize the unfairness of the current situation. Legislation alone will not fix this problem. We need to change the culture of bail court decision-making. At its core, we must remember that innocent people are being jailed. Many of these folks are not subsequently found guilty of the offenses it's alleged that they committed. So the reality is that people are being punished. They are serving what amounts to a sentence prior to and often in the absence of conviction. In the report, we outline a number of recommendations that we would like to have considered going forward. Some things that we want to think about are creating hurdles to custody, similar to what is outlined in the YCJA. Thinking about how we might provide guidance and direction to structure discretion. We might consider decriminalizing charges around failing to appear and failing to comply. This is not to suggest there shouldn't be a response to these kinds of allegations, but that we might want to look at decriminalizing. We need to support the police. The police have a great deal of power to release individuals and indeed are the gatekeepers into the court system. We created judicial referral hearings, an opportunity to take when there are allegations of failing to comply through a different system than mandating arrest and being held for a bail hearing. This is an opportunity to divert more minor matters from the bail court so that bail court can focus on those that are more serious. We must improve case processing. Faster bail decisions, moving people through the system in a more efficient and expeditious manner, will reduce the amount of time that people are held in custody, the amount of time people are subject to conditions and supervision in the community, and hold people accountable for the offenses they have committed in a timely fashion, and release any one of those who we have mistakenly brought into the system, bring them back out as quickly as possible. We want to focus our efforts on improving bail supervision, the different kinds of programs that we might be able to provide some kind of monitoring and checking in process with individuals. But these programs must focus on the principles of bail rather than behavior modification. For example, removing some of the eligibility requirements and restricting the imposition of additional conditions outside of court oversight. We can also look at investing in bail beds so that folks that do not have a stable or permanent address, that they have a place that they can go to stay, alleviating some of the primary ground concerns. At this point, I'm going to turn it back over for a couple of additional comments.
Thank you, Nicole. I just have one comment to make on some of the recent remarks that we've heard regarding judicial independence in Ontario. As we're aware, there have been some legitimate concerns raised about partisan appointments to the judicial appointment advisory committees in this province. And In the view of the CCLA, the findings of this report illustrate why it's imperative that judicial appointments remain nonpartisan and based on merit to ensure that the charter right to bail is implemented in a manner that upholds the rule of law. And comments from those responsible for the appointments to these committees that we should modify the decision-making of justices of the peace or of judges by injecting different concerns into the process to appoint them are deeply worrying and concerning. And we'll now be happy to answer any questions that you may have.
Clarification about one of the things you said.
Yes.
You said most of the people are not convicted of what they're accused of. Is that because they plead guilty to a lesser charge as part of a deal?
It's difficult to disentangle some of the factors that play into this. It isn't, most people do ultimately plead guilty rather than having their matters go to trial. But what seems to be happening then is that we've really moved the sentencing phase to the front end of the system and are putting people through these pieces. And by the time we've had an opportunity to look at the evidence most closely, charges are being withdrawn because there's no reasonable prospect of conviction or it's not in the public interest, or that the court may perhaps look at and see that they have gone through enough on this front end that there is no further need for intervention.
It's fair to say that it's very rare for somebody to be released without any charge at all, to have the case completely dropped.
No, in 51% of cases, all charges against the individual are withdrawn, and so they are not found guilty.
Okay. So, obviously the government of the day is very much in favor of tougher bail laws.
Yes.
And some of the things you've talked about here about diverting some of the lesser cases away from bail court. Do you think there's a middle ground here where the government can have its tough approach towards repeat violent offenders and still pursue this idea of getting people who may be a first offender or haven't done anything violent away from bail court?
I mean, I think there certainly are opportunities for us to talk about how we want to focus on those that are most serious and most risky, and how it is that we want to focus our attention there and move away from targeting those who are most minor. But at the end of the day, we also have to remember that our constitutional rights are not reserved for some people accused of offenses. They're reserved for all individuals. And until somebody has been proven guilty, until they have been convicted, we should be very restrained in the kinds of interventions that we're imposing in their life.
And if you don't mind, I'll just add one piece to that, which is that it's important to recall that existing bail laws do permit the detention of individuals if it's necessary for public safety, and that the rate at which bail has been denied has been increasing significantly. And so the notion that we have a system where repeat violent offenders are just released en masse regularly is itself somewhat of a myth. There are, of course, exceptional cases that we have to examine in terms of what occurred in the circumstances, but in general, there are many, many, many cases where individuals are released with charges that may involve accusations of violence, but where they do not reoffend while out on bail.
Just circling back to the Premier's appointments of his ex-staffers to the Judicial Appointment Advisory Committee, what traditionally has been the process, and what is the process that you would like to see as opposed to what the Premier's decided to do?
Well, certainly there's always been some degree of discretion that the government has possessed to appoint individuals to these committees. The concern, I think, that arises here in particular is that the Premier has discussed the motivation for these appointments as explicitly being to alter how justice of the peace and judges are making decisions in accordance with the law. I think what we'd hope is that anyone appointed to one of these committees has relevant expertise and experience, and that the motivation for their appointment is based on their ability to add a needed perspective on those committees, as opposed to a language that suggests that they are being appointed to ensure that only a particular kind of justice or judge is appointed in the province of Ontario.
This is not new, though. Doug Downey has said for a while that he's wanted to appoint judges that are more in line with his own thinking. They have introduced bills to allow him to reject some of this committee's shortlists. So this is not new. Are you worried that like the judges that they have appointed up until now are already causing this problem to happen?
Yes, I am worried. And at each of the stages that you spoke about, where there have been these statements or indications made by the Attorney General, you'll recall that many members of the legal community expressed their concerns. So what we think is important is ceasing this approach to how justices and judges are appointed. It should not become the norm that the executive can regularly state that appointments are being made on these kinds of grounds, that it's critical that these types of appointments and the consideration of justices and judges is motivated solely and exclusively by upholding the law and not these types of extraneous concerns.
Is the Premier right that this is just a normal part of politics? Like, governments appoint people that agree with them? Is that not a normal thing?
Well, I think it's important to recall what the role of a Judicial Appointments Advisory Committee is, which is to appoint individuals to a part of our government that is exercising its functions in a nonpartisan manner in accordance with the law. So when thinking about that special role and the role of the judicial system, it's imperative that it isn't politics as usual. I think we all know too well what occurs when a judiciary becomes just another partisan exercise of government, and it's imperative that we avoid that situation becoming the norm in Canada.
I would say it's probably fair to say the recommendations of this report are not going to be something the Premier is going to want to go forward on. So if that is the case, what needs to happen next for in terms of advocacy or getting people to like rethink the bail issue? Because the Premier's take on this seems to be ascendant. He got the federal government to go along with what he wanted on this issue. It seems like he has the moment here. How do you plan on changing that?
Well, I think the efforts of the CCLA and other organizations have had an impact both in shifting the public debate and leading to legislative changes that are aligned with the concerns we raised. So, for example, with respect to Bill C-48, which is the most recent federal reform with respect to the bail system, you'll note that after passing lock, stock, and barrel in the House of Commons, there was serious scrutiny raised about the bill in the Senate before the Senate Committee on Legal and Constitutional Affairs, and a report issued by that committee that specifically called upon the need for evidence-based reform and cited many of the issues that are reflected in this report's recommendations. In addition, that bill was amended in part due to the efforts of the CCLA, which proposed this amendment to require greater scrutiny of those who are vulnerable or marginalized where a bail decision is being made. So there's no question that there is a dominant political narrative around bail, but that the efforts of organizations like the CCLA, of groups representing marginalized and vulnerable groups, in bringing these issues to light will lead to a difference in terms of how they are considered and legislated on.
Political pressure that's being put on the system is a result of a public's perception that there are people out there that have committed violent crimes, getting bail, and reoffending while they're on bail. And that's the public's perception. What do you say to the person that has read in the newspaper and the media, heard about a shooting that was a result of a person that was on bail?
Well, I'll provide a brief answer, then I'll hand it over to Professor Myers. We support public safety. We understand the public's concerns when they read a story like that. The point of our report and our recommendations is to say that we have to look at interventions that are actually going to address the concerns that the public might have. If restricting bail was the answer, then we should see crime at an all-time low in Canada because it's been restricted for decades, more, and more. The real solutions to the types of issues that the public is concerned with that you cite is to examine recommendations like having stronger supervision programs on release, like having bail beds available, and of course looking at the actual contributors to criminal activity, improving people's social and economic conditions. And so those concerns by the public are well-founded, but they deserve a real answer as opposed to what is occurring now. Professor Myers?
Thank you. I wholeheartedly agree that this is what we're looking at, is that we've got that nobody's arguing against public safety. All of us would like to feel safe and should feel safe in the communities. The difficulty is that the measures that are often being put forward are knee-jerk or sort of tinkering and are very unlikely to result in the kinds of changes that we're looking for. We need to be mindful that any time held in custody, even short periods of time, is criminogenic. It makes people more, not less likely to commit offenses. So if we're really honestly interested in improving public safety, holding more people in custody is not the most effective way to do that. And what we want to then be able to do for those who are most risky and who are causing us the greatest deal of concern, that there's a small group of folks that may need to be detained, may need to be subject to supervision and conditions. But remember, 51% of cases have all charges withdrawn. So we are scooping up a lot of folks who do not rightly belong in the system, and we need to get them out.
With the province and the premier unlikely to sort of hop on adopting some of these recommendations, are there, I mean, I know you, I can't remember which one of you, but spoke to the John Howard bail bed program. I'm wondering if there's any other either community organizations or programs that you see that are already sort of working with these recommendations or these values kind of at their core?
I mean, John Howard is one of the organizations that runs bail programs. There are different organizations across the country that participate in this kind of verification and supervision. And so I think what we want to do is look at how do we best bolster and support those programs? How do we think about what kind of sort of broad and knitted together type of operation that they have, that so we see some kind of consistency across spaces, and then to funnel our resources into supporting people in the community rather than such things like bail compliance units that are meant to surveil and be and sort of monitoring folks. I'm not saying that folks don't need monitoring, but what we need to be doing is supporting people rather than penalizing at this particular stage.
Do you feel that support can come when there are things like specialized bail prosecution teams and the initiative you just mentioned?
The bail compliance units. I mean, I think there are spaces for these pieces. I think that the difficulty is what happens in these conversations is that we hold up the rare, the unusual, the sensational as though that's the norm. And we should be deeply concerned about what happens in these rare and sensational cases, but we can't take them and use that to sort of extrapolate to what we should be doing for everybody. And I continue to go back to that starting point. If we're interested in public safety, let's do what works rather than what just sounds good.
Not related follow-up, but maybe a little granular, but there was Bill C-75,
yes,
I believe, which was the judicial referral hearings, which was, as I understand it, supposed to avoid a certain amount of detention in bail review. But in the report, it seems like a lot of counsel and people who work within the system say that they just haven't seen that happening. Are you able to speak to why that might be or how that could be?
Yes, absolutely. I mean, I think some of the difficulty is that by the time Bill C-75 was really, coming into force and effect, the pandemic landed. So in some ways, we could see some disruption there. But I think the other difficulty is that simply the processes that have to then follow the creation of this haven't been put into place. So do police officers know that this is an available option? Is there one that they can then turn to? And so when we're then speaking with those who work in the system and they're saying, I've never heard of this or I've never seen it, there's no system then in place for the police to even try to use this as an additional option in their tool belt.
Who's supposed to start that?
That's a great question. I'm not sure who would be responsible for that. Likely also then you have the jurisdictional differences between the provinces and territories.
Thank you.
Thank you.
No calls. Perfect. All right. Thanks, everyone.
Thank you.